program, A Conversation with Gabe Davis, Executive Director of the Cincinnati Citizens Complaint Authority, is co-sponsored, gee whiz, must have had marbles for dinner, co-sponsored by the Cincinnati Public Library. I want especially to thank Amy Katzman, who organized this program with our program committee, chaired by Jeff Dye, VP for Programs. The Citizens Complaint Authority was established nearly 20 years ago. It was one of the efforts undertaken to improve police-community relations after the death of 19-year-old Timothy Thomas as he was fleeing police and the civil unrest that followed. A class action lawsuit by the Cincinnati Black United Front and the American Civil Liberties Union of Ohio, an investigation by the U.S. Department of Justice of patterns and practices of Cincinnati's police division led to a collaborative agreement signed in August 2002 with the Fraternal Order of Police. The agreement called for the adoption of community problem-oriented policing and other reforms. The agreement was monitored by the Justice Department until 2007, based on assurance that the reforms were being fully implemented. The city also established the Citizens Complaint Authority to conduct independent investigations regarding complaints against police officers. The CCA was initially chaired by Nancy Minson, a Women's City Club member, who was a strong advocate for good government and mental health. Over the years, the CCA languished a bit due to lack of funds and attention, and now it is being revived under the leadership of its new executive director, Gabe Davis. Amy Katzman will now introduce our speaker in more detail. Thank you, Amy.
And thank you, Beth. I want to say that if you had been drawing up the ideal resume for a candidate for this position, you would have come up with what we have for Gabe Davis. He's a native son, born and raised in Cincinnati to a family with a tradition of public service. He's the son of a retired Cincinnati police officer and a Head Start manager with the Cincinnati-Hamilton County Community Action Agency. He attended Cincinnati Public Schools and matriculated from Seven Hills Schools, where I have it on good authority. He was a very good student. He got his BA in political science from Yale and followed up with a Juris Doctor from Harvard Law School. He was an assistant DA with the Manhattan District Attorney's Office and a federal prosecutor in the Civil Rights Division of the U.S. Department of Justice. At the Justice Department, he prosecuted hate crimes as well as law enforcement misconduct. His civil rights prosecution work required him to lead investigations across the country, including in Ohio. When he moved back to Cincinnati with his family, he joined the law firm of Frost, Todd. I always do that. They're not Frost, Todd, and Jacobs anymore. They're Frost, Brown, and Todd, where he worked as a litigator until he left in 2020 to become the CAA director. We're lucky to have him here tonight. And thank you for being here to help us understand your agency and your vision for it.
Well, thanks so much, Amy and Jeff, for those warm introductions, and Beth as well. It's a pleasure to be here with all of you today. And I see some familiar faces from folks here and some friends, so that's just fantastic, including my Seven Hills high school teacher for chemistry, Linda Ford. So it's always great to be in the presence of folks who have helped me get here, as well as friends and active folks from our community. So thank you very much for having me. I'm going to go through the presentation here and hopefully just take about 30 minutes or so, a little bit less if I can, to go through the slides. And then I really want to get to your questions and make it more of a conversation and have it feel really intimate in terms of what we're talking about. The topics are obviously of great interest, and we're coming up on the 20-year history of some important milestones for our community. So I can think of no better time to really delve into these topics. And we'll just kind of jump right into it if I can get the PowerPoint up and running here. Just one moment. Okay. Jeff, you looking good?
Yeah.
All right. So what I want to do is just talk a little bit about our mission statement and also take you through the history of CCA just in very brief detail, go through our organizational structure, talk about our investigations process and how we handle cases, how we get them, how we investigate them, and then talk a little bit about the board. We work with a 7-member citizen board, and I want to go through what they do a little bit and what their function is. And then I want to take you through a case scenario and just take you through a real life example of a situation that we assessed a few months back and just show you how we analyze that case and the kind of things that we consider when we're making our determinations in these investigations. And then I want to talk briefly about some challenges that we're facing here and some opportunities at CCA, and then take some questions from all of you. So CCA's mission is to investigate serious interventions by police officers. And that includes cases that involve discharge of firearms, those are your police shootings, officer-involved shootings, any cases involving deaths in police custody, any cases involving major uses of force. And that term is not really defined in our statute, but insofar as we understand it from precedent, that really means cases involving some serious injury, some medical treatment that results from that. At a minimum, those kinds of cases we lump under that major use of force category. And then we also review and resolve all citizen complaints against police in a fair and efficient manner. So even if your complaint is not fitting one of those other buckets, we will assess that, we will review that, investigate it, and resolve it, assuming it meets one of the criteria that we will go through in a moment. At a minimum, we have jurisdiction over complaints that allege excessive force, improper pointing of firearms, improper stops, improper entries into homes or vehicles, improper searches or seizures, discrimination complaints, and those include complaints that allege racial profiling. And our goal at CCA is to address citizens' concerns and to improve their perceptions of quality police service in Cincinnati, but to also improve the delivery of those services. So our job is to not only ensure some mutual trust, but also to improve policing in Cincinnati. We take those goals very seriously. So the history has been commented on, so I'll just touch on it very briefly, but I'm sure you all are well aware if you've been in Cincinnati for quite some time, but we had back in 2001 a series of incidents, uprisings in over the Rhine that resulted from the shooting of an unarmed Black man named Timothy Thomas, who was 19, and he was being arrested for a nonviolent misdemeanor, and mostly based on some traffic citations, and he was shot in over the Rhine, and that really touched off a series of disturbances that really rivaled what had happened in early 1990s with Rodney King. And I think up until that point was the largest period of unrest since the Rodney King civil disturbances that took place. And so as a result of Timothy Thomas's shooting and the uprisings and distress, or disturbances, I should say, and combined with some lawsuits that had been filed previously, and there were a series of lawsuits filed by the ACLU, as well as the Cincinnati Black United Front also joined in the lawsuit. And because of these things, combined with the unrest that we saw, and also combined with shootings that had occurred leading up to that point, where essentially 15 Black men had been shot, or I should say had died during confrontations with the police in years prior, these things came to a head and led to the creation of a collaborative agreement. And the collaborative agreement required Cincinnati Police Department to adopt community-oriented policing as its dominant strategy. And I'm sure you've heard a lot about that already from Chief Isaac. I understand he was here speaking with you a few weeks back, so I'm not going to go into all of what the collaborative entails and what community-oriented policing entails. But you should just understand that really was a groundbreaking agreement that really ushered in this new period, that community-oriented policing was the dominant strategy for how to do the enforcement of law and community police relations in Cincinnati. And that's been the mark that's been set ever since. We also saw here in Cincinnati that there was a memorandum of agreement that we entered into between the DOJ, the city, and the police department that, combined with the collaborative, really ushered in a lot of these reforms and led directly to the existence of Cincinnati Citizen Complaint Authority. These were enacted back in 2002, and that really is what gave rise to CCA. Again, I'm not going to go through all the points of the collaborative. I think you have a pretty good sense of that, but I can take questions on that at the end. So as a result of the collaborative, CCA was formed, and some of the key outcomes really called for the creation of an independent and impartial forum. That was very important, that everyone understand that there'd be an independent body that was not answerable to the police department, and that was also independent of other city government functions, and that it could do its work independently and unbiased. And those were key values embodied in the creation of CCA. There's also an understanding that CCA had to be an investigative body, that other oversight bodies similar to CCA across the country, some of those bodies have other types of oversight authority. Some bodies can do monitoring. They can look over the shoulder of police officers and investigators to see if they investigated a complaint properly. In our case, we don't just do monitoring. We don't just do that form of oversight. We also created with investigative authority, which means we do independent investigations that are really driven and led by staff here that are parallel to whatever's happening at the department. And we also have what's called administrative authority, which I can unpack in a moment. So our structure really is as follows. We have a director, and then that's my position. We have a team of investigators and professionals that comprise the staff, and I manage those folks in their day-to-day operations and duties. And we also have an advisory board that's comprised of 7 citizens that are appointed by the mayor and that are approved by city council. And those folks don't that's not something that the staff takes part in, but the mayor heads up a process by which he takes applications, makes a decision, and then those folks get vetted by city council and approved. You see their names there, and they serve for 2-year terms. You can serve up to 2 2-year terms total, and those terms are staggered. This just shows you our structure and how that's laid out graphically. The city manager is my supervisor, so she appoints me and hired me, and she can remove me upon consultation with the board. As I stated, there is some independence there. It's really written into the law that we operate under. And so the day-to-day operations are really run by the director without any interference from City Hall, but certainly I can be removed if need be by the city manager, and any director can be. I work with the board, and the board has a very important role, but they do not oversee staff. So that is certainly my job as director. At the end of the day, our work does get assessed though and reviewed and approved or disapproved by the board. So the complaint investigation process really unfolds as follows, and it kicks off with the intake process, which is very important. And people should understand that, we take complaints in a variety of ways. So you don't have to just walk in person, although you can do that if you like. Certainly now their offices are back open. They were shut down for a minute due to COVID, but we reopened those offices. But if you want to file in person, you can, but you can also file over the phone. And there's a phone number you can call, and you can be connected with an individual right away who will take your complaint over the phone and will kick things off. You can also email us your complaint. You can go online to our website, and you can file that way through an online form. You can file on social media. It's a little unorthodox, but if you want to send us a message over Facebook, or if you want to send us a message over Twitter, you can do that as well, and we'll follow up and take your complaint that way. If you're really old school, you can fax us your complaint. You can just take that form, you can fill it out and fax it over to us, and we'll receive your complaint that way as well. So once we get that complaint on file and we have an investigator reach out to you to figure out what's going on with your issue, we'll investigate that complaint, assuming it meets a set of criteria. And I'll go through the allegations that we investigate, kind of unpack that a little bit, and how those differ from allegations that we don't investigate. But assuming that we do investigate it, we will assign an investigator to you. That person will conduct a review and an analysis of the facts and the information and compare that, hold it up to the legal standards and the regulations and the rules, and make a determination as to whether or not any policies, procedures are violated. And then findings will be issued. There'll be recommendations that can be issued as well that pertain to matters of corrective action or disciplinary action. If we think that an officer has stepped out of line or has violated a policy in such a manner as to warrant some discipline, we can recommend that. We can also recommend policy changes as well, and changes to police training. And once we do issue our findings and recommendations, the board reviews that work. And then after that, the city manager has the final decision based on the board's assessment, and that gets passed on to the police chief after the city manager has weighed in. So just to go through our investigations in a little bit more detail, those are really governed by Article 28, Section 3, which is our enabling statute, as well as by the memorandum of agreement between the DOJ and the city. And both those documents have a pretty clear set of guidelines that structure how we do business at CCA and how we investigate our cases. Okay, so what complaints does CCA investigate? So, I talked a little bit earlier about our mission statement, and we went through some of the allegations that we investigate in that mission statement. And that's going to be on your left-hand column, that list, and that's your discrimination cases, your racial profiling cases, improper searches and seizures, excessive use of force allegations, improper stop allegations, and those can be either car stops or pedestrian stops. Any allegations involving the improper pointing of firearms, any discharge of firearm allegations, or any discharge of firearm circumstances, even absent an allegation. If there's a shooting, we're going to be on site investigating immediately, even if there's no complaint. We also, again, investigate any death in custody cases absent a complaint. On the right-hand side, you see what we term our secondary causes of action. And these are allegations that we will investigate if they're accompanied by one of the primary allegations that's on the left. So for instance, you'll see there, the first bullet point says discourtesy. The next one is lack of proper service. And those are, I'd say, our top two secondary causes of action. If you call us and if you say an officer was being rude to me, they pulled me over and they were discourteous, perhaps they used some profanities, some colorful language, and you feel mistreated by that experience. If your only allegation is a discourtesy and there's nothing else that you're alleging that was improper, that's a secondary cause of action for us. We will not investigate that if that's your only allegation. We will take that complaint on intake. We'll listen to your concerns. We'll hear you out, and we'll forward that on to the police. They have an internal process that handles those kinds of allegations, and it's called the CCRP process, the Citizen Complaint Resolution process, and it really involves a sort of mediation type model that CCA is looking to play a role in potentially in the future, but currently, insofar as it exists, we've never really played much of a role in that process. And so those complaints will go there. But if your allegation is that an officer was discourteous to you or was rude, and also the officer used excessive force, or if the officer was rude but also pointed a firearm at you as well, then we will investigate the primary allegation as well as any secondary allegations associated with those things. So just because we don't investigate discourtesy in isolation does not mean that we never investigate it. We do see quite a bit of those allegations and investigate those, but typically they're accompanied by these other more primary allegations. So our investigations utilize a basic protocol that basically calls for us to review the allegations that are made, to gather, review, and analyze the evidence, and to interview all the parties involved and witnesses. And that's very important because we have to have live witness statements to really assess our cases properly. We also get body-worn camera footage, which is also very important. But oftentimes we find that the cameras either don't tell the whole story, or the camera may not have been worn or turned on at the proper point in time. And so it's always critical to have witnesses who can tell you from their perspective what happened. And we go through great measures to obtain that testimony. And we don't have to subpoena, for instance, police officers to come down and speak with us because they have to do that as a condition of their employment. But we can subpoena other third parties if people refuse to testify or refuse to provide statements to us. We've not done that in the past, to my knowledge, but we have the ability to do that. And I'll touch on that in a moment. But that witness testimony is pretty important for us. We also do obtain the body-worn camera footage, like I stated, and review that pretty exhaustively and get all the camera angles and make sure we have a proper understanding for what was captured by the cameras. We also obtain any documents, so any police paperwork, use of force reports, arrest reports. If we can get our hands on medical records, if those are pertinent, we will seek to do that as well. And we analyze and gather all the facts, and we do that independently of the police. We don't, we certainly, they give us their documents, but we do not do joint interviews with the police department. So if they're investigating a case, they'll interview the witnesses, and then we might bring them back a few weeks later and interview those witnesses, or vice versa. But we're not going to do parallel witness interviews with the police. It's very important for us to maintain that independence and that credibility. Once we gather all the facts and interview all the parties, we interpret all the applicable laws, regulations, procedures, and make a determination as to whether or not policies, procedures have been violated. And we analyze all those things using a preponderance of the evidence standard of proof. And that's actually, I'll defer talking about that for the moment, but that's the standard that we apply to looking at the evidence, and I'll circle back to that. At the end of the day, we provide that analysis and we recommend action where it's necessary, either on the corrective and or the policy change end, as I mentioned. So our findings in our cases will be one of the four, and this is one of the more dense slides with words, so I apologize for that, but these are verbatim the definitions that we apply when we are seeking to issue a finding as a result of one of our investigations. And the four findings are as follows. The first finding is the unfounded finding. And we issue that finding when the investigation determines that there are no facts to support the incident complained of actually occurred. So I'll give you an example. If someone comes in and they tell us that they were pulled over by a police officer, they were stopped while driving their car, they were taken out of the car, and then they were tased, and that's the basic allegation. If we determine that the car stop never occurred, that it just didn't happen, or if we determine that the car stop did happen, but that there was never any tasing, the tasing did not take place, we will say that that is an unfounded allegation. The next finding is your sustained finding. And that's where the person's allegation is supported by sufficient evidence to determine that the incident occurred and that the actions of the officer were improper. So to take that tasing allegation again, if the person had said, I was pulled over, I was taken out of the car and tased, and if we determine that the person was pulled over, they were taken out of the car, they were tased, and that use of the taser violated police policy, training, procedure, or violated the law, then we will issue a sustained finding, essentially stating that it did happen and it was wrong. The next finding is our not sustained finding, and that's where there are insufficient facts to decide whether the alleged misconduct occurred. To use that example again, if we determine that tasing, that we can't say whether or not it occurred, for instance, let's say that we don't have body-worn camera footage, it's a he said, she said, and we have no way to break that credibility tie, or if there's another incident where we often see there are allegations of racial profiling or things of that nature, and if we can't really peer into the mind of the officer because we lack a pattern, we lack any bad conduct, the interaction is otherwise permissible that occur between the officer and between the citizen, and there may be one factor that gives us some pause, but if we can't determine because we lack facts to decide the question, then that's a not sustained finding that we will issue. The last finding is the exonerated finding. And that's where preponderance of the evidence shows that the alleged conduct did occur, but that it did not violate policies, procedures, and training. To use that tasing example again, that if we determine based on the evidence that the tasing did occur, that a car stop did occur, but that those things did not violate policy, that the officer is permitted to stop the car, permitted to tase the passenger or tase the driver, then we will issue an exonerated finding on that allegation. And so that's how those allegations work and how our findings work in conjunction with the allegations. And again, these are administrative investigations, so these purely deal with whether or not someone is an officer is to be disciplined or met with corrective action or not. I mean, those are the kind of stakes we're talking about. These are not criminal investigations, so we can't prosecute anyone. We don't have that authority. In a former life, I had that ability, but CSA does purely administrative work. What that means is that officers have to answer our questions because they can't take the Fifth Amendment. It's not a criminal proceeding, so you have to cooperate with our investigations as a matter of law and as a condition of your employment. Again, we apply that burden of proof by preponderance standard. And so that's essentially stating or asking, does 51% of the evidence favor one side or the other? And if it's ever so slightly in favor of one side or the other, if the evidence breaks ever so slightly in one direction or the other, then that burden has been met by preponderance and we can issue that finding. We have 90 days to complete our investigations absent extenuating circumstances. And I will tell you that we have not met that time frame for quite some time due to our staffing issues, due to some issues involving funding over the past decade. Really, we have not had the full slate of investigators to really tackle cases in as timely a fashion as we would like to. So we do not routinely resolve all cases within 90 days, but that is certainly the benchmark, and that is certainly what we are aiming for. So once we finalize the investigation, and once my team does the hard work of collecting the evidence and analyzing that evidence, they will write a report that can be, depending on the complexities involved in the case, it could be 1 page if it's a very simple case, it could be 2 pages, it could be 20 pages. And that report will analyze the findings or analyze the evidence, I should say, in light of the rules, and will issue findings or make recommendations for findings. That means the director that I have to then take a look at, and I have to say, hey, does this merit some more attention, or is this good to go? And at the end of the day, if I approve of the work of the investigators and there's no further steps to be taken on a case, I will issue that report to our board, and the board will review that investigation report. And they meet in open every month, the first Monday of the month, in an open public forum, and they review those cases that we pass on to them after we complete them. And the board really is there to confirm the completeness of our investigation. It's written into the law that the board's not supposed to reinvestigate the case, so they're not doing a review from scratch. They're really taking what we give them and they're asking And did the team do a complete assessment? And do we agree or disagree at a basic level with the conclusions that are contained in the investigation reports? And the board can agree or disagree in whole or in part with what we do. They don't have to adopt our conclusions. They can issue their own findings on a case if they disagree with the findings that I have issued, or they can issue their own recommendations. If they don't like a recommendation on a policy matter, they can say, we're going to go in a different direction, or they can decide to issue our recommendations and adopt those in addition to their own recommendations. And I mentioned earlier that we have subpoena power at CCA. That really runs through the board. If we think it necessary, I can recommend a subpoena. The board can authorize that. Ultimately, it has to be approved by city council. And that only would be needed for third parties, really, if you're talking about some witness or some institution, perhaps where you're looking for evidence. When it comes to the police department, we don't need to subpoena them because they give us information routinely as a matter of course. It's baked into the statute and also a requirement of officers' employment. Once we do our investigations and once the board assesses those, then that report gets sent on to the city manager again, who can agree or disagree in whole or in part and makes a final determination and has the opportunity to either adopt our conclusions or not. And she also has the opportunity to issue directives as a result of our recommendations, and the opportunity to also issue corrective action or to make those directives to the police if she chooses to do so. So I'm going to go through a case scenario here, and we're going to go through this pretty quickly, so I do want to get on to your questions. But this is just one case that we handled a few months back after I started, and it involves several different allegations. I'm only going to really talk about the ones that are highlighted in detail here. But in essence, this is case number 18185. The allegations involved allegations of improper search, of improper procedure involving a body-worn camera use, and an improper procedure regarding a consent to search form. And I'll go into those in more detail here. So the gist of the complaint was this. On September 14th of 2018, Ms. Julie Jeffries alleged that Cincinnati police officers stopped her son in a vehicle and took him into custody at gunpoint. Further, Ms. Jeffries alleged that police officers improperly entered and searched the residence of her mother, Marcella Juergens. And so that was the gist of the complaint that was filed. It mostly dealt with the search, and that's what I'm going to talk about today. I will just tell you in short here that the allegation involving the improper pointing of the firearm was one where we exonerated the officers on that because the officers did point the firearm to get the car to stop, but police officers are allowed to do that under certain circumstances, and this was a case where we felt that was appropriate. So we did not issue a sustained finding on the gun pointing allegations, but we did issue some sustained findings on the search conduct, and I'll talk about that right now. So in this case, the police officers obtained a written consent for the officers to search the home of Marcella Juergens, and she was the grandmother of the person who was stopped at gunpoint. And so, in essence, the police officers, before searching the home, they produced a form. They said, "Will you sign this form to let us search your home?" And there was some back and forth, and the grandmother signed the form. However, the police training provides that a consent to search should only be limited to the places or things that a person expressly or impliedly authorized to be searched. And that was pretty clear from the training materials that we looked at. It's also a pretty clear principle of the law that the person who's giving the consent can decide how much consent to give or not to give. And so in this case, there was some consent given to search the property. The question was how much consent was given, and did the police comply with that consent or confine their actions to the scope of that consent. So the body-worn camera footage showed that prior to signing that consent to search form, the grandmother in this case indicated her belief that the officers only intended to search her grandson's bedroom. And when she tried to clarify that point with the officers, the lead officer responded, "Just his room because he told us." And then the officer added that they would search his room and anything out in the open. That's a quote. They were to search his room and anything out in the open that might harm her or that might harm the officers. And only after receiving those assurances did she sign that consent to search form. Well, our investigation determined that rather than limit the search to the residence to the bedroom and anything out in the open, as the officer stated and as we understood the consent to allow, the officers proceeded to search the entire residence, going inside of drawers and cabinets. They went well beyond just the bedroom for the grandson and didn't just confine their search to areas out in the open. They were going through and inside of things in a manner that really was beyond the scope of that consent. And they were going far beyond just searching for things that were out in plain view. If there had been something out in plain view, that's out in the open, that's one thing, but they were going searching for things far beyond what she had agreed to. We also discovered that several body-worn cameras were turned off too early before the completion of the search. And so while the cameras that were turned on gave us some insight into the fact that the officers were going into cabinets and drawers, there were several officers who were involved with the search who did not have their body-worn cameras turned on for the entire search. And that's very problematic for a lot of different reasons. To kind of, again, touch on some of my former experience as a prosecutor, we get allegations at times, criminal allegations that officers were planting things on people or stealing things from people, things like that. And while those things were not alleged in this case, it's always a risk when officers are doing searches and search warrants when they're not recording those searches, because if someone comes back and says later, the officer planted, a kilo of cocaine in my bedroom, or the officer, stole $500 from me, we want to know whether or not there's video that might disprove or prove those things. And so it's important that we that those cameras be turned on for any searches, and that's consistent with the policy. That wasn't done here, and they also again went beyond the scope of the search as they were as we saw it. And so we sustained the officers for an improper search in this case, making the determination that we had established by preponderance based on the statements that have been made and based on our assessment of the video and our understanding of police policy. We could determine that by preponderance that the officers did in fact conduct the search and that they did it in a manner that violated policy, training, and procedure. And we also, again, sustained for that body-worn camera for the improper procedure for them turning that off too early. And that's just an example of how we make decisions on these cases. There were other allegations, like I mentioned, that we cleared the officers from, the allegations involving the pointing of firearms. I think there was also perhaps a discourtesy allegation in this case due to some colorful language that was consistently, it was used consistent with police policy. And so we cleared the officers of that in this case as well. But we certainly, were there issues, we point those things out, and we definitely take that very seriously. We did so here. So that's the case there I wanted to go through, and we have other examples, but that's a pretty recent one, so I did want to highlight that one. So some of the challenges that we face at CCA have been touched on before in this conversation. We have a backlog that is rather extensive. I think the last I checked, about a week or so ago, we had about 120 cases that were in our backlog, and that's not our total caseload. Those are the cases that are older than 90 days. And, so it's a significant issue. And we had some staff furloughs during the pandemic and had only been operating with 3 investigators when I started. In some cases, over the years, we only had 2 investigators. We're supposed to have 5 investigators under the statute at a minimum. And so, for the past decade, we've only had 2 to 3 instead of the 5 that we've needed. We've gotten into a bit of a hole here, frankly. And so we have to dig ourselves out of that. But that's a real challenge for us, because if we have a backlog, then it inhibits our ability to really be effective for a lot of reasons, and really frustrates citizens and officers who are involved in our cases. Another challenge is we have limited capacity to fulfill some non-investigatory duties. In addition to our casework, we also are responsible for doing pattern analysis. We're supposed to not only look to see whether or not we can resolve complaints and whether or not the evidence establishes allegations, but we also are supposed to look at trends. We're supposed to be looking to prevent complaints from being filed by analyzing pattern circumstances that might give rise to complaints, and by identifying what we call pattern officers who might be leading to complaints, who are problematic actors, and also pattern complainants as well, people who file complaints repeatedly, so we have a better understanding for how to place those things into context. So we're supposed to be doing pattern analysis, and we're supposed to be doing some mediation work as well. That is called for us to be doing restorative justice work. And that's written into our statute, but we've not, for the entirety of our existence, really gotten into that game in a serious way, and we're hoping to do so in the future with a subset of cases. We also are hoping to do some increased community engagement, but we've been limited in doing that as well because of the staffing challenges. But certainly that's an opportunity for us to do a little more in the way of information dissemination and education. But it's been a challenge nonetheless to really get to the point where we can do it at the level that the community expects. And all these things are driven ultimately by funding challenges. And we have Thankfully, the city of Cincinnati allocated some new funding for us for the current fiscal, and so we were able to hire new investigators when I started. But even with the new hires that we made in December, we frankly still have a need for more, just given the hole that we're in. And so we've gone back to the well, so to speak, and have made additional asks for more funding for additional staff hires to help us do our investigations and also fulfill some of these other duties of ours that don't relate to investigations per se. Okay, so I'm about 30 minutes in, so I want to take some questions here, and I have some stats as well that I can talk about, but I'd much rather take your questions if you have any and have a conversation. So thank you very much for listening to the presentation portion, but I'm eager to have a dialogue.
I wanted to ask some questions about what are the repercussions from your finding?
That's a great question. So at the end of the day, CCA cannot directly discipline an officer. We don't have that authority to
Right.
issue reprimands or suspensions or to fire officers or what have you. What we can do is we can make recommendations on the corrective side. We've not been as aggressive in the past at doing that as we probably should have been in some cases. It can be tough to hammer out a set of criteria for being consistent in that, but what we should be doing going forward, and what I have pledged to do, is to set up a system where we have clear criteria that can say, if we have an officer who has repeatedly engaged in misconduct and we're sustaining him for that conduct, him or her, we got to be able to make a recommendation that's a strong recommendation that may be corrective or may be disciplinary in nature. And then the city manager, upon receiving that recommendation, has the opportunity to act on that. And again, we can't make anything happen, but we can certainly make recommendations backed up by the evidence. And then when we get into those discussions with the manager and with the police department, we can make our case as to why we think some corrective actions are merited. And I expect we'll be doing that with increased frequency in the future. I also would say that in addition to making those sorts of recommendations, I think there's real value on the accountability side in having the information out there. I can tell you that that as an attorney, putting on my attorney hat, I used to be a defense attorney as well after being prosecuted for a little bit. And attorneys are awfully interested in if you have a client and knowing what an officer has done in the past that may make that officer less credible as a witness against the government in the prosecution. And so when you have situations where police officers have engaged in misconduct, and when CCA shines light on that and publishes that information, that is a tool that a defense attorney can use in court to hold an officer accountable. And that has implications for that officer's career advancement, for the cases the officer can work on. And it really does matter. And I think some of these things are the reasons why when we issue sustained findings, even though we lack the ability to directly discipline an officer, the officers will come to our board hearings and they'll speak out against our findings and try to get the board to essentially go against what we have found in our investigations. It doesn't happen all the time, but it happens with enough frequency that it's clear to me that there is real power in us being able to say something happened here and it wasn't right. Because when we do it, they show up to fight it. And I think it's because of some of these things that we're talking about, where they don't want the specter of discipline. They don't want to be cross-examined on a criminal case about some misconduct allegation and have that hurt their career. So those are just some of the things that result.
May I just ask a follow-up?
Sure.
To whom do you publicize this? Who has access? Are the findings private? I mean,
yeah.
Does
So
the public know this stuff, or is it in-house in your records? Or
that's a great question. So this information, it's on our website, and you can go online right now. The website is it's on the screen there, but we can go online and there's a section where you can go to our board meetings and you can see what the summaries are for all the cases that the board has heard and voted on. And the summaries of each case are going to have for you the names of the officers. It's going to also have the name of the complainant who filed the case, because nothing that we do is really protected by the open or the public records request laws. All of it is subject to that. So it's all public. But you can find the name of the complainants, the name of the officers, and the analysis of those reports is going to show for you all the allegations and all of our reasoning behind our findings and what our conclusions were. And anyone can access that at any point in time after the board takes a vote on it, and typically even before the board votes, so it'll go up on the website at least about a few days before, so people can see in advance of the meetings. And then we invite the public to come to the meetings also, so the public has a chance to really hear those decisions being weighed and can also express their opinions before the board takes votes.
Okay, we have some questions in the chat. The first one is from Rhonda. What is the police union's role, if any, in the disciplinary process?
So the police union, they don't have a direct role in CCA's process in the sense that it's very clear that once we issue our findings, those go on to the police chief and those go on to the city manager. And those are institutional actors that have to be a part of that conversation. Now, the union is not excluded from expressing their preferences on any given case. And if an officer wants the union to be involved in their case, then the union will receive a copy of the complaint. And the union can also be involved earlier as well if the officer wants them to be a part of the interviewing process. So that they have the opportunity to bring a union rep to that meeting that takes place where they're being interviewed by our folks. So the union can be involved, but the union is not an institutional actor in the same way that the police department commanders are, in the same way that the police chief is. And so at the end of the day, their best opportunity to really influence what we do is to come to the board meetings and speak out against those things if they don't like what we're doing, just the same way as any citizen can. Once the board issues their decision, that goes on to the city manager, and there's no formal role for the union at that point in time before the manager agrees or disagrees with our decision. Now, I can't stop the union from reaching out to the manager and saying, hey, we're going to write you a letter. We don't like this case that CCA decided, or, picking up the phone. I can't prevent them from doing that, but there's no formal role for them in the process after our board meetings and really influencing what happens as far as it relates to CCA's finding in that case. Now, at the end of the day, if the manager decides to, the manager with the police chief, if they decide to impose discipline for whatever the reason, the union can file a grievance on behalf of a client against any discipline that results. And we saw this happen in a case recently. Actually, it wasn't that recent. Actually, it was from 2019. But CCA just concluded its investigation recently on the case. But there's a case involving a police officer who used a racial slur while arresting a Black woman at a nightclub. And this was in the paper, so you might have heard of this case. But he called her the N-word, and while he was arresting her, and he was investigated for discrimination and for the discourtesy. And ultimately, the police department decided to suspend him as a result of this. And CCA finalized its case recently in its investigation, but the suspension was to occur some time ago. Now, the union essentially filed a grievance based on that determination that was made by the police department. The union fought that suspension, and the union was able to get the arbitrator to agree to essentially reverse that suspension, because in the arbitrator's opinion, the police department was not being consistent with how they had handled other people who had used racial slurs in the past. And so the union did not think they were being consistent. There's some disagreement about this, obviously, but at the end of the day, the union reversed that suspension and imposed a much less severe penalty. And so, I'm sorry, not the arbitrator reversed that, imposed a much less severe penalty. That was in response to the union filing that grievance. So the union can play a role if there is disciplinary action at the end of the day. And I'm not an expert on or certainly not shouldn't say I'm not a participant in the police disciplinary hearings that take place, but the unions can also give advice to the client, obviously, during the course of those internal police department hearings, and can be involved in some capacity in what happens there as well. But insofar as what CCA does, their role is quite limited.
Thank you.
Another question that came up, which relates to something you just mentioned, is you mentioned the board and you mentioned the city manager. Does the board typically agree with the staff recommendation? And also, does the city manager typically agree with the board's recommendations? So
Yes, so those are great questions. I mean, the board typically agrees with the director's recommendations and findings on a case. It doesn't always happen that way. When I started, there was a case where, to the former question, the union came to the board meeting and said, hey, we think that the investigators got it wrong, and the board was swayed by the union's argument. And so the board disagreed with staff and with the director's recommendations and findings in that case. But that's pretty rare. For the most part, the board will agree with what our staff is issuing and putting forward. And then at that point, the manager is reviewing a unified opinion from the director and from the board. And when that happens, at least from past experience, what the data shows is that the manager tends to agree with CCA in those cases. I think in upwards of 90% of our cases that have been actually reviewed and assessed by the manager, there's an indication of agreement with our decisions. And there's a form that accompanies the reports, and the manager signs off and states whether or not she agrees or disagrees. And most of the time, there's agreement there. Now, that does not necessarily mean that what happens as a result of that agreement is a different conversation, but certainly whether or not there's agreement, for the most part, the manager does agree with what CCA concludes and with what our recommendations are at the end of the day. And same thing for the board.
There's a very lengthy question in the chat. I don't know if you saw it. It's actually a lot of subparts from Queen to Hira. Why are police using stop and frisk as a tool of gentrification? Why are complaints in District 1 not being addressed? What training do these officers receive as it pertains to the collaborative agreement and how they deal with the Black community? Why are officers not required to have drug testing, especially if they have repeated complaints and questionable behavior? Do citizens review these complaints, or is it only the investigators? Who are these investigators? Names? And thank you for your responses. So it's a very lengthy question, but we'll see what you can do with that.
Yeah, I think I'll just pick up a couple things that I heard that speak to me and see if I can address some of the concerns. So, we certainly have an interest at CCA in understanding what the data is on police stops in Cincinnati. And this is a much broader topic than just what our complaints reveal to us. And there's an ongoing project that's taking place right now between the police department, the manager's office, CCA, and some community stakeholders that are also invited into the process. So Iris Broley is someone who also is a part of this group to really assess whether or not we have a bias-free police department in terms of traffic stops and arrests. And we're working on right now a framework to be able to study this question, to have better data to understand the scope of the problem and the scope of any disparities that exist. What I can tell you is that certainly from our complaints, what we see are an awful lot of traffic stops that do result in complaints at the end of the day. And I think that those stops are a key driver of our complaints. That doesn't mean that all the stops are invalid or bad stops necessarily, but we do see that those confrontations and those traffic stops, for whatever the reason, are driving a lot of complaints and a lot of dissatisfaction between citizens or from citizens. And a lot of those traffic stops are also resulting at times in searches that are problematic, where officers, may pull someone over and, maybe they have probable cause to search the car, but they don't have enough cause to go inside the person's pockets, who was driving the car. Those things are different. And I think sometimes you see that officers don't always follow the proper training on some of these things. And the car stops and traffic stops can, in my view, kind of lead to more of this behavior that may be problematic at the end of the day. So, it's a complicated topic, but where we see stops and frisks and searches that are inappropriate and that violate policy, we call it out. We don't hesitate to say, this is a bad stop, this is a bad search, and we're going to speak that truth, and we're not going to sugarcoat it when we see those things. When it comes to District 1, if there are things happening there, I just encourage anyone in any district to file a complaint with the CCA, file with the police department. We get all complaints as a matter of course from the police department. So if you file with them, we are going to see it. If it fits one of the core allegations that we investigate, we're going to investigate it. And even if we can't investigate it, we're going to still listen to your story. We're going to track that information. And at the end of the day, if you are not understanding what's happening with your complaint, once you forward it on to the police department, if we can't handle it, we will follow up with them. We'll ask them, hey, what's going on with that referral that we sent you? We want to know what's happening with that person's emergency case. So we're always available for folks to use us in that way. And if something's happening in any district, we invite people to feel free to file complaints with us and with the police department about those things. I think there was certainly some I think one of the comments or questions was about police training, and we have a great interest in ensuring that the training is embracing best practices, certainly, and that officers are receiving the training that they need in order to do, rule-abiding constitutional policing in Cincinnati. And we think that the police department has a great training program. It's not perfect. Where there are areas where we think they need to improve upon that, we make those recommendations to them. And where officers do not abide by that training, then we use that as a basis to, again, sustain them for misconduct, as we have done as we did in the case that we discussed earlier, where the search was not consistent with how they're trained. So those are some of the things that I heard, but happy to touch on other topics.
Okay. The next question I found in the chat is one that you'll like, because I know that you have a slide for this. The question is, what are the percentages for each of the categories: exonerated, sustained, etc.? And I peeked and saw that you have a slide for this question.
I do. Let's see if I can pull that up, and then maybe we'll
Right.
See. Okay, 1 second here.
There you have it. Yeah.
Okay, so this is our 5-year findings trend, and you can kind of see over time the percentage of our findings, or not the percentages, these are just raw numbers of the findings and how they break down. So you'll see that in 2020 we had a total of 79 sustained findings, 75 not sustained findings, 103 exonerated. 103 exonerated findings, and then 48 unfounded findings. And I can tell you, just based on, if you look at it as a percentage, we certainly, I think, increased our percentage of sustained findings over 2019 from 2019 to 2020. So the numbers, I think reveal pretty plainly that we tend to, for the most part, exonerate an awful lot of things. But this also is taking each allegation as an isolated allegation. So one case could have 10 allegations, and we might find that, of those 10 allegations, 7 things were done correctly, but 3 things were done incorrectly, or 2 things were done incorrectly. Doesn't mean that the 7 allegations that we cleared are no indication that the 2 things that we found were problematic or not important. And sometimes it's quite the opposite. Sometimes the things that we're seeing that are issues are very problematic, and sometimes they're not. Sometimes we just, we're clearing an officer, we're saying nothing was done wrong here, and this complaint is not a well-founded complaint. So it really just depends on what the facts reveal.
Okay, Amy, you had a question. Do you want to ask it? Because you made an edit to it, and I figured you could ask it better than I could, putting the 2 together.
Okay. I just wanted to know where the pressure point is for full funding of your organization, particularly now that the Department of Justice is no longer really involved.
Yeah, that's a great question. I mean, it's and I didn't mean to cut you off. You just had a second part to that.
No, it was just a continuation of that. I mean, there's a law defining how many employees you should have, investigators you should have, and there are no consequences for the law not being capable of being followed. So that was just the extension on the question.
Sure. No, I mean, the funding is a real challenge for us. I think you highlighted an issue. I mean, we have a law that pretty clearly states that we have to have 5 investigators at a minimum, and we now have that 5, but for a decade we did not. We also have it stated pretty clearly in the law that City Council, must provide appropriate resources for us to complete our mission, fulfill our mandate, and obviously, we've had some challenges over the years with the funding. So it's it's not something that I think I have a perfect solution to, but I think that's part of the reason why we like talking to groups like yours and why we like getting the word out about the important work that we're doing, is because at the end of the day, you have an opportunity to petition those who represent you, the citizens, and say, hey, we like what CCA is doing, or we want them to do more, and we think you ought to be supportive of them where it counts. And so that's something that we definitely welcome any advocacy that you are willing to engage on our behalf on these things. But certainly, what we seek to do is to always do our best work, and then to always talk about those things when we're done with the folks who make those decisions, so that they can have what they need in order to give us what we need to do our job at the end of the day.
So our job is to lobby on your behalf for funding.
I will say that as a certainly as a city employee, we are not permitted as city employees to lobby city council for
But we are.
funds for our departments. So I certainly cannot tell you to go out and lobby city council. But as citizens, you have First Amendment rights as citizens, and we welcome citizen activism and advocacy on behalf of CCA at City Hall.
Well said.
Another question that came up is, do other cities have CCA type overseeing of police behavior, and which cities have the most effective systems and provide the best models for this work?
That's a great question. Other cities do have similar versions of what we have here. I think we got there a little earlier. We've been at this for 20 years, although we have due to some of the challenges that have been pointed out, we're seeking to revive things a bit now and kick them in higher gear. But we've been around for a while. But a number of other cities have also done this work for quite some time. I know San Francisco has an office that is very similar to ours. New York City has a CCRB, which operates with a somewhat similar structure to ours, where they do investigations and they have hearings. You also have an office similar to ours in DC. It's the DC Office of Police Complaints that has a model that's quite similar in some ways to what we do here, with a full team of investigators and staff, and then a board that kind of operates alongside that. So you do see across the country, certainly in some of the bigger cities, there also is one in New Orleans as well, that we have similar oversight agencies that exist. And it's exciting because right now we are seeing these become adopted even more so. I was on a call a couple of days ago with the folks up in Akron. They're trying to stand up their own version of this, or at least they're beginning to I should say they're beginning to have a serious conversation about that. At least they're not at the point yet of pulling the trigger, but we had a discussion about it, and they're very interested in our work down here. We also have folks up in Columbus who recently approved a version of CCA to exist up there, and we have been on calls with those folks as well to try to help them get that going. So this is really sweeping the region and the country in a lot of respects, this new model of civilian oversight. And not all of them are investigative. Some of them are more that monitoring function where someone's there to kind of look over the shoulder of the internal investigators that the police department has. But I think the more robust model, certainly that have independent staff, I think it certainly has a little bit more punch to it. I think we're beginning to see a lot more of that model being embraced. It's a lot more expensive, frankly, than the monitors model, but we're beginning to see it becoming embraced a lot more by folks who really want a robust mechanism for accountability, especially in the age of George Floyd and Breonna Taylor. People want something tangible that they can do and can push forward to really bring about some change in the space.
I guess sort of as a related question, this also came up in the chat, is do you plan any innovative approaches to carrying out your mission? That's sort of an add-on to what you've just been talking about.
Sure. Yeah, so I think one thing we have to do, and it's not so much on the investigative side, but it really is on this mediation side, is we're supposed to be doing mediation work through CCA. And the complaints that I talked about earlier, those sort of secondary causes of action, are complaints that we just shuttle off to CPD. And they have a mediation process in place, but it's not, it's one that's purely police driven and led. So a citizen meets with the police sergeant. They meet over at the district or at police in a police building, and there's not a neutral mediator who's mediating a discussion. It's the supervisor, the citizen at the police department, and we think that there's other models for how to do a mediation-driven sort of approach in a way that's much more user-friendly, much more community-friendly. And we're looking to play a bigger role in working with CPD on that. And it's, I don't want to get ahead of processes that are playing out, but I think we're looking to really get in this game and to ensure that cases like your discourtesies, lack of service, that those cases are ultimately being handled in the most community-friendly, user-friendly way, where the citizen walks away feeling as though they had a chance to be heard, and also to confront the officer. And that when that doesn't happen in our investigations, because in our investigations we're talking to a citizen and we're talking to an officer, totally separate processes. But this mediation model is the citizen's chance to really confront the officer and say, hey, here's how you made me feel when you pulled me over, or when you said that to me. And a lot of our complaints come in that way. We investigate probably roughly 1/3 of the complaints that we get. Most of the complaints we get are of these discourtesy complaints, lack of service complaints, that we think could be better handled through a better, more community-friendly mediation process. And so we're looking to get in the game there. We think that'll do a lot to generate some goodwill between community and police, but also to hopefully free up some time to handle some of the more serious cases, and to weed out some of the repeats, the repetitive situations that we currently see that might slow down our overall processes. So that's one thing we're looking to do. We're also looking to mobilize citizens to do community outreach and have a more community driven model to our information dissemination. We're having something called the CCA Ambassador Program, which really seeks to train a core of volunteers to go out and give our PowerPoint presentation to different community groups, and to staff community functions, and to hand out our brochure, to hand out our complaint forms to folks who want that information. And we really want to empower volunteers to help do some of that work. And so that's one thing that we're also looking to get into. And there are any number of other things as well. I think we're looking also, this is on the investigation side, we're constantly looking at our training for our interviewing techniques and how we do those things. That we have seen that oftentimes these interviews with officers can get uncomfortable if you have someone who doesn't like being questioned about an encounter with a citizen, and no one likes being second guessed, and no one likes having someone question whether or not they did something correctly or incorrectly. We think there's some techniques that might help our folks handle situations better where there are tough interviews, and might also lead to some better information gathering. So we're constantly refining and looking at our training and looking to get better at doing these witness interviews, is one other example.
You just raised a question, or you mentioned training, and there are a couple questions that relate to that. One is, what training do the investigators have, and how does your staff stay unbiased? The other is, how do they not feel vicarious trauma from hearing so many complaints and also realizing they can't see all the cases? Another related question is also, what do you know about how the police are trained in the area of courtesy? Do they do any role playing, et cetera?
Yes. So the training that staff undergoes, it really varies. We, on the first, as a threshold matter, we try to recruit people who already know how to do interviews. For instance, our 3 new hires, one of them was a former prosecutor with the Cleveland, Cuyahoga County Prosecutor's Office. So you do a lot of questioning of witnesses and a lot of that kind of investigation work as a prosecutor, just based on my experience. So we wanted to bring people on who could hit the ground running. We also hired a former counterintelligence analyst, an investigator with one of our intelligence communities out of DC. And I'm not going to tell you which intelligence community. I don't know if I'm permitted to say that, but she brought significant experience when it comes to interviewing folks in that context. And we thought that was a huge value add for us. We also hired a former NYPD detective who had done a lot of that type of work investigating cases in New York City. So we try to hire people who have experience doing the work, but we do supplement their training when it comes to this basic orientation about what CCA is and how we operate, but also, they go through a course of training at the police academy, frankly, about Fourth Amendment law, search and seizure policies, because we want to understand how police are training their folks, but we also want to just get a sense for what the latest police technology is. And so that they go through trainings on how the tasers work and how the de-escalation trainings run at the academy. And so they're exposed to those sorts of things. And they also have taken recently, a number of them have taken some increased witness interviewing training as well to supplement their skills. When it comes to how they manage to stay unbiased, I mean, that's obviously a challenge for anyone, right? And we all bring our perspectives and our backgrounds into our professions. And I think our investigators are no different. But I think it really starts from just setting the tone from the very beginning that, we have a job to do, that we are professionals, and, we all have passions and interests, but our job is to follow the facts wherever they lead. And we drill that into folks when they start. And we every meeting we had with our board, we emphasize that we're not here to put our thumb on the scales. That, and in fact, again, I will refer back to Article 28. It's pretty clearly written in the law that we're supposed to be unbiased, and that we shouldn't be yielding to any particular agendas of any particular persons, and we're supposed to call it like we see it. And so we pride ourselves in that. We follow the facts where they lead without fear or favor. That was always how I operated as a prosecutor. That's how I expect staff to operate. When it comes to police training on de-escalation, I'll tell you that they go through robust training on a lot of things. I don't know for certain what their training is on training on discourtesy, not de-escalation. I don't know what their training is on discourtesy per se. I think I know that they have pretty clear policies on discourtesy that say, coarse language, profanity is to be discouraged, and as a default, you can't use that when talking with citizens. There are certain limited exceptions when you can use profanity, when you're trying to get someone to, for instance, drop a knife or drop a gun or comply with a demand, and you want to. There's an ability that police officers have under their policies to use profanity under those circumstances, but they can't use it to attack a person or to name call or anything like that. So I know that the policies are quite strict. I can't tell you what the training is exactly on that. And there are a lot of situations that kind of are not as stark as profanity, but that may just be basic rudeness and basic, just lack of customer service skills. And I think those are things that, there could probably be some improvement among some folks on. And that's why it's important for us to have, a robust mediation program, but also when we see that in our cases to sustain those findings as well as we do.
There was another question about when does the CCA board meet, and are those meetings online?
Yeah, so the board meets the first Monday of every month. They meet at 5 p.m. And the meetings are online, so you can go onto our website, usually a day or so after, and you can click a link and see the meetings in their entirety. And those are stored for the past 5 years. So you can go back if you want to, 2000 and 17, 2018, and take a look at what our meetings have been and watch as much or as little as you want. And it's a great resource for community members who want to catch up on what happened on a case. If you can't come and your case was being called, you can pull that up and you can see how that was debated, how it was discussed. And we're looking to really make our website more user-friendly as well. It's one of the things we have listed as an improvement project for this upcoming fiscal year, is to make it easier to find information. It's all there, but people don't often know that it exists. We definitely want to make that easier to find.
Wow. Oh, there's still new things coming into the chat. Harriet asked, are you familiar with private complaint mediation service, which mediated misdemeanor cases for the city of Cincinnati? Cases were referred by officers, the court, and private residents. Some of the mediators and trainers of the mediators for this service area I can't read.
They're still around.
They're still around. Okay, sorry about that. Would you consider hiring any of those persons or use those resources in some way?
Thanks.
Yeah, I'd be open to a conversation about it for sure. I think we're looking to really do some research to figure out what resources are out there and available locally, certainly for this. There are different models around the country for how to do this work in this context, and some of them call for using paid mediators, some call for using community volunteer mediators who are nonetheless trained. And I think we'd be open to considering whatever resources are here locally for that. And as we're working currently, having some discussions with the police about their program, and I imagine we'll be factoring in a lot of local resources as we move forward through this. But I think it's an excellent idea to rely on folks who are already trained to do some of this work and already have a background in it, for sure.
You want any names? I worked for him for 8.5 years, but I'm familiar with a lot of the people who work for him.
That'd be great if you want to email them to me or drop them in the chat. I'm happy to take them.
Okay.
I guess one general question, and I think you might even have a slide about it, is what can we do as Woman City Club to help going forward?
Yeah, that's a great question, and I'm happy you asked. I think there are a couple of things, and we touched on some of the funding earlier and some of the citizen advocacy. So I won't rehash that, but I think that certainly is one important thing that can be done is average citizens have a lot of power with folks that make decisions, and more so than what people realize. And I think having folks make phone calls or reach out is very helpful. But also something as simple as liking our Facebook page and sharing our social media content. It sounds simple, but it goes a long way toward helping us amplify our message, getting out what we're doing, and reaching a new generation of folks. Certainly during COVID-19, a lot of things are happening virtually, and so having that's increased support in that space is very important. And then sharing content through other means as well. If you feel so inclined, write an op-ed, write a letter to the editor about what we're doing or about these topics, and I think that all helps to build some enthusiasm around our work and ultimately some support for us. And I'd say also look out for opportunities to really join that CCA ambassador program. We're not ready to launch it quite yet; it's in its infancy, but we're hoping to really have a core of volunteers who can really help us to carry that message out. And we're looking to be very active at community events when the world resumes, getting back to normal, so to speak. And so we love to have some folks who can hit the ground running and who can go and can staff a table somewhere and can put on a CCA t-shirt and be that presence for us. So be looking out for those opportunities. And then if we do end up doing any sort of mediation work that involves community mediators, and if we have capacity for folks to help out in that way, we certainly would probably welcome people to sign up to be trained in that as well, to help in those capacities. So I would stay tuned on those things, but certainly in the short run, I think just talking this up a little bit, sharing our content, and engaging in some other forms of advocacy would be helpful for us.
And then Amy had a question that I think is a way to put a bow on the whole discussion. What would you say the impact of the CCA has been on police practice and community relations in the 20 years before your arrival?
I think we've had a significant impact. I really do. I think people don't often know that we are around, but CCA is an institutional player that has a seat at the table, but exists to bring community voices into that space and to give them, in essence, the seat at that table. And I'll just give you an example of a recommendation we made recently as it pertains to the use of body cameras that was something that the community had been asking for quite some time. And it wasn't really getting done. But in a number of cases, we recognized that there were situations where police officers were in plain clothes, were engaged in police actions that were quite overt, in the sense that they were engaging in searches and they were executing warrants and they were handcuffing people and were presenting themselves as police officers, but they were dressed in plain clothes, so they were not in uniform. And police policies did not require officers who were in plain clothes to wear body-worn cameras ever. And so you could be in a plainclothes assignment, and engaging in law enforcement activities openly, not covertly, but you didn't have to wear a body-worn camera at all. And so we had situations where we just didn't have evidence in our cases to understand what had really taken place because the officers who did most of the work didn't have the cameras, and the citizens couldn't get their hands on the cameras, and they felt like there wasn't transparency. And that was problematic in our view for a lot of reasons. And so we made recommendations quite steadily that the police change their policies to require those body-worn cameras to be worn by officers in plain clothes. And due to those recommendations and due to just work in collaboration with the police on this and constant discussion of these topics and the importance, I'm proud to say that they adopted that recommendation in January. They changed their policies to require all officers who were wearing a police vest or who were otherwise openly engaging in law enforcement conduct, not undercover officers, but people who were outwardly police officers, to have to wear body-worn cameras. And I think that's a significant change that they have been communities been seeking. So I think that's just an example of the way in which CCA brings community concerns to an institutional forum and gives you a seat at the table and can get some real change done. And I think we've been operating that way for the past 20 years in big and small ways to really make things a little bit better here in Cincinnati. We're not there yet, not perfect, but I think we have a head start over some other places around the country. We have a model that works, and we really do have a department that does support our work. And I don't say that lightly. We don't see eye to eye on everything, but I think the police department, by and large, sees CCA as value add for what they do, and they see the importance of it from the community police standpoint at the end of the day. And so that's a valuable thing to have in this community, and we work hard to maintain that role of not only a robust watchdog agency that's going to provide some oversight and we call it like we see it, but we also try to cultivate that collaboration where we can, so that we have that working relationship that really can get some things done on behalf of citizens. And I think we've operated that way for 20 years.
Well, I think that's what we have for questions that have come in so far. Amy, did you want to say anything in conclusion?
I want to thank everyone for their attention, and obviously I want to thank Gabe for his efforts and presentation. And I think I need to turn it over to Beth to talk
Absolutely.
about what other events are being offered by Women's City Club.
Okay, well, I would also like to add my thanks to Mr. Davis for the very important work that you're doing, and sharing your sharing your time and expertise with us this evening. And we will certainly make an effort to support your work because we believe in it. And so thank you on behalf of all of us. If you are a member of Women's City Club, and we thank you for your support. If you're not, and you enjoyed this presentation this evening, we encourage you to join. We have some really terrific activities coming up in the next 2 months. One is a presentation by author Denise Kiernan on Tuesday, May 28th. She will be speaking about generations of grace, inspiring women who shaped American history. This is the title of her, is drawn from her new book, We Gather Together, A Nation Divided. She's written 2 other books as well. One called The Last Castle, about the Vanderbilt Mansion in Asheville, where she lives, and another about the women of Oak Ridge, entitled Girls of Atomic City, who worked on the Manhattan Project. On June 3rd, we will have our annual Agnes B. Season Good event, and we always have a speaker who's a leading woman in the community. And this year it will be Elizabeth Pierce, the CEO of the Cincinnati Museum Center. And this is the occasion on which we present our education awards. And this year we will be presenting to 6 lucky and deserving students in order to help them seek higher education. And on June 27th, which is a Sunday, we will be celebrating the dedication of a statue on the riverfront in honor of Marion Spencer, who was a leading civil rights activist in Cincinnati and president of Women's City Club. So I hope you will join us as a member and for those wonderful events. And thank you again for attending tonight.